Can the government seize a $95,000 plane because a passenger used it to transport a six-pack of Budweiser? The Alaska Supreme Court says yes, but the U.S. Constitution says no. I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice, and I'm here with co-host Keith Neely and IJ attorneys Sam Gedge and Kirby West. We'll discuss an outrageous new case from the last frontier and how forfeiture interacts with excessive fines, free speech, and more. This is Beyond the Brief. So we just launched one of our wildest forfeiture cases. Can you tell us a bit about what's going on in Alaska?
Sure. So, Kim, we're representing an 82-year-old gentleman named Ken Jopi. Ken was a pilot for much of his adult life, and we are going to be asking the U.S. Supreme Court to take up a case from the Alaska Supreme Court, where that court said that the state of Alaska could forfeit Ken's $95,000 airplane because one of his passengers had a six-pack of Budweiser in their groceries. I see your eyebrows raising. It's a pretty wild case, as you said, and you will not be surprised to hear that it implicates the excessive fines clause of the Eighth Amendment. There's a fundamental mismatch between the seriousness of having a six-pack of beer, and we can talk about kind of the underlying law that's giving rise to the forfeiture. But I think at a gut level, there's a fundamental mismatch between the seriousness of that offense and the cripplingly punitive sanction of taking someone's entire airplane. So that's in broad brushstrokes what the case is about.
So what is this underlying law that's kind of underpinning this forfeiture here? What was the problem with him having a six-pack of Budweiser in his plane? Was he drinking it and flying around? Like what was the issue?
So he was not. It wasn't even his beer, and the plane didn't get off the ground. But so Alaska has what's called a dry village system, and various states in the lower 48 have what they call dry counties, dry communities. But typically those are relatively relaxed. Like you can drink in dry counties in Arkansas. You can oftentimes buy alcohol. It's more regulated than in other areas. There are certain parts of Alaska, though, where kind of a dry county means dry county, where villages vote not just to regulate the sale of alcohol and limit it to certain license holders, not just to regulate the importation of alcohol, but to ban the sale, importation, or even the possession of alcohol within their community. And there's some reasoning behind that. Alcohol abuse is a problem in Alaska. Like, we don't want to downplay that. That's absolutely true. But one of the kind of quirkier parts of the law is that while kind of violating the dry village statute in a low-level way can give rise to pretty lenient criminal sentences. It's a Class A misdemeanor. So Ken, our client, was sentenced to a $1,500 fine and 3 days in jail. There's also a parallel forfeiture provision under which if you use a plane to violate this dry village statute, the plane's getting forfeited automatically, no matter whether you're a first-time offender like Ken was, no matter the amount of alcohol, whether it's a six-pack of beer or an entire pallet of Jack Daniels, no matter really anything. All that the state needs to know is that there was a six-pack of Budweiser on your plane and it was heading towards a dry village, and that's enough for them to take your plane.
You emphasize the word plane. Does it apply to cars, boats, other forms of transportation, or is it just planes?
So that's another kind of quirky part about it, because yes, it does, except when it comes to other kinds of vehicles, cars and boats, the statute actually kind of recognizes a hierarchy of seriousness of offenses. So if you use a car to transport alcohol into a dry village or a boat to transport that alcohol, it's not necessarily going to get forfeited. It's eligible for forfeiture only if kind of you are a recidivist, or if you're a felony parolee, or if it's a substantial amount of alcohol, if it's something like twice the amount that's presumed to be for sale. So when it comes to other kind of vehicles, there's at least an effort to calibrate the forfeiture with the seriousness of the crime. It may be imperfect, but they're trying. But when it comes to airplanes, all bets are off. And I think Ken's case really spotlights how important something like the excessive fines clause is to checking those kinds of really outlier forfeitures.
Why are the planes even getting punished? Like, Ken had virtually no association with this woman, right? She's just a random passenger customer. So it sounds like you're saying that she didn't really face any consequences, but Ken is getting punished. How does that make sense?
No, that's a great question. And so, yes, right, the six-pack of Budweiser wasn't even Ken's. And so just to give a little bit of background here, right, so Ken ran an air taxi service, kind of a one-man business, Ken Air LLC, flies locals and tourists kind of all over the Alaskan wilderness. It's an extraordinarily cool job. He did it for decades. And because a lot of these small villages in Alaska don't have grocery stores or kind of other kind of shops, people who live there often have to go to the big city of Fairbanks or other kind of larger communities in order to do their shopping. And so this was a repeat passenger. She wasn't a drinker herself, but she was in town for a couple of days. She and her sister went to the local grocery store, picked up a ton of groceries. So Coke cans, food, soda cans, and 3 cases of Budweiser and Bud Light. And she packs it all up in a bunch of boxes, and she has chartered with Ken to fly her to the village of Beaver, which is where her husband works. And she's flying up there to spend some time with him to celebrate her birthday. And in all of that luggage is this set of alcohol. As they're loading up the plane, alcohol interdiction cops show up. They search the plane. They find the beer. Ken standing there saying, I had no idea that this woman had beer in all of these boxes of groceries. But the police basically said, well, at a minimum, there was one six-pack of that Budweiser was in a translucent bag on the top, and you were at a minimum willfully blind to that one six-pack, and that's enough to trigger these misdemeanor criminal charges, and that in turn is enough to trigger the forfeiture. Just to circle back to, I think, your comment, Kim, about kind of the mismatch between, the actual offender, if you will, getting a much lower punishment. The passenger was also charged with that misdemeanor. She pleaded out, and the sum total of her punishment was kind of what you would expect on the criminal court side of things. She gets the $1,500 fine. She gets the 3 days in jail. She moves on with her life. But now, 13 years later, you have Ken, the pilot, the air taxi guy, still fighting to kind of keep his $95,000 airplane for this same offense.
How did this take 13 years to drag out? That kind of blew my mind there for a second.
Yeah. It's wild. It's wild, Keith. Just remember our last big excessive fines case, Timms versus Indiana, that went on for something like 9 years. So I guess we've got that one beat. We have a new record. But yeah, the case has been dragging on forever. The state really has kind of viewed this as their white whale, I think. And I won't belabor kind of the procedural history of the past decade and a half, but it's gone up and down the appellate court system a couple of times. At first, the state trial court said, actually the statute doesn't actually authorize this forfeiture because he didn't actually import any beer into the community. The plane was stopped before it took off. The Alaska Court of Appeals says, no, this is good enough. It falls within the statute. Back down to the trial court. They hold an excessive fines hearing. The trial court says, really kind of does what we think is the correct fact-intensive excessive fines analysis and says, this is pretty much conspicuously the lowest seriousness. This is a cumbersome sentence, but kind of the lowest level offense you can conceive of for this kind of violation. You're forfeiting the guy's $95,000 airplane over, even 3 cases of beer. This is a bit much. It's excessive. Goes up to the Alaska Court of Appeals. The Alaska Court of Appeals says, well, you need to find more facts, trial court. And then we get to the Alaska Supreme Court. We're now 12 years into the case. Ken's now 82. He was a sprightly 70 when this started. And what the Alaska Supreme Court said is really kind of radical because they basically said, we don't really care about the specifics of this particular case. We don't care about the specific level of culpability that Ken had. We don't care if he was culpable for the 3 cases of Budweiser or only the 6-pack, because even if it's a 6-pack, that's a big deal, and we're just going to basically outright defer to the legislature. They said a forfeiture is okay here, and we're not really going to second guess that.
That seems to kind of render the excessive fines clause a bit of a dead letter, doesn't it? If courts are just going to defer to the legislature anytime they decide to impose a fine, then when is a fine ever excessive?
I think that's right. It's a softball question, Keith, but I agree with you because really I think the fundamental problem with how the Alaska Supreme Court addressed the issue is that instead of doing what the Supreme Court did in the one excessive fines case that they've actually grappled with, that was back in the late 90s, the Alaska Supreme Court really didn't take into consideration at all the facts of Ken's case. And that, I think, is where you see one of the fundamental divisions in authority among the lower courts, because you see, courts like Indiana's in Tyson Timms' case. You see courts like Utah's, like Pennsylvania's, like the District of Columbia's, like the Ninth Circuit's, the federal court that Alaska sits in. All of these courts are saying, a faithful application of Supreme Court precedent in this context requires us to look at the specific level of the defendant's culpability, determine kind of where they fall on that spectrum of culpability, determine what harm their violation caused, and really trying to isolate, how bad is this person, so that we can weigh the gravity of their offense against the seriousness of the forfeiture. And what you see the Alaska Supreme Court doing is basically at every turn saying, we are going to examine the gravity of Ken's offense at the highest level of abstraction. We are going to look at the kind of maximum theoretical penalty that a worst case offender could have gotten for this offense. And because that maximum penalty was $10,000 in fines, well, $95,000 is, quote, only 9.5 times higher than the maximum pecuniary penalty that the worst conceivable offender of the statute could have gotten. So that's not a big deal. We're not going to look at the harm from Ken's violation, because years ago, the legislature had a few sentences of legislative history saying, alcohol abuse can lead to fetal alcohol spectrum disorder and imposes lots of costs on the public health system and can lead to death, all of which is true at a extraordinarily abstract level. But the question here is, should we be saddling one 82-year-old bush pilot for kind of all of the harms of alcohol abuse writ large? And our submission is that the answer is no.
So I want to talk more about the, actual forfeiture element of this in a minute, but let's first step back, because we've been talking about how this case has been going on for 12 years. IJ has not been involved for 12 years, right? So how did you guys find out about this, and what made it go from something you were aware of and paying attention to something that IJ intervened in?
Yeah, so that's correct. We've only gotten involved at the cert stage now. It has kind of occasionally been on the radar of one or more IJers over the past 13 years or so. We were talking with our colleague Justin Wilson in communications about the case, and he was like, this kind of rings a faint bell, and he went back to his emails from 2014, and there was like an email exchange about like, oh, there's this weird case coming up in Alaska trial courts.
Wow.
So, but yeah, I mean, when the Alaska Supreme Court's decision came down in April, it really just jumped out as just a real, I guess it really kind of captured a lot of the confusion that we see in the lower courts about how seriously should we be taking the excessive fines clause. Just an airplane for a six-pack, like it just at a gut level captures your imagination. And so we reached out to Ken and his current lawyer. My colleague Mike and I flew out to Coeur d'Alene, where Ken now lives, with his delightful dog Maya. And we kind of taken it from there. I think it really is a great opportunity to spotlight the importance of the excessive fines clause, and especially kind of in the modern day, right? The excessive fines clause did not get a lot of attention from the courts for most of our nation's history. It's really kind of starting to have a comeback over the past couple of decades. And it's critically important in the modern day to be taking this Bill of Rights protection seriously, where you have civil forfeitures exploding, where you have more and more civil fines, criminal forfeitures, all kinds of economic sanctions getting magnified as all levels of government view kind of the criminal justice system as a way to pad their budgets. And even if you go back to the 1600s with the English Bill of Rights, if you go to the 1700s, a recurring concern from kind of the British Parliament, from the framers, is that kind of fines and forfeitures raise a unique concern about being kind of used in a way that just mismatches with the crime because they stand to make the government money. And we see that every day now in 2025.
Does it matter that Alaska's statute, it sounds like, mandates the forfeiture of the plane, right? Like, it isn't as though the statute says, here's the list of things you could potentially do to punish somebody and kind of giving some discretion. It's, you have to forfeit the plane. So does that make the whole statute, in your view, unconstitutional, or how do you think about that?
No, I don't think it makes the statute as a whole unconstitutional. I'll note parenthetically that up until about 20 years ago, the statute, in fact, did make these airplane forfeitures discretionary. So there was some flexibility for trial courts to kind of do kind of the common sense thing in these kinds of cases. But no, so in kind of the foundational Supreme Court case in this area is called Budweiser from the late 1990s. There, too, we're talking about a mandatory forfeiture of all cash that was brought basically into or out of the United States without reporting it. If it's over $10,000, the statute says we got to forfeit all of it. Hosep Budweiser didn't report his $350,000 of money he was taking with his family through the LAX airport. And so there too, right, the statute's saying this has to get forfeited, but the Supreme Court says, well, okay, obviously the statute can't trump the Constitution.
Right.
And so what the excessive fines clause requires is this fact-intensive analysis of kind of, is there any kind of relationship between the severity of this punishment and the seriousness of the crime? And here too, the question we submit is is there any relation between the seriousness of forfeiting Ken's $95,000 airplane and the actual predicate crime here, which the Alaska Supreme Court assumed was simply that one six-pack of beer. Like in many ways, the Alaska Supreme Court kind of cleared the table in its opinion of any kind of fact disputes here. They basically said, we don't think the trial court needs to go back and think about whether he was culpable for the six-pack or the 3 cases. I don't know. I would argue it's still excessive even if the 3 cases were on the table here. But the Alaska Supreme Court said, no, we don't care. Like let's spot him the six-pack, and we still think that it's totally fine.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost-efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
Kirby, Sam has talked a lot so far about criminal forfeiture, and I know that you've done a lot of work with civil forfeiture as well. Is there a difference here that's kind of relevant to the excessive fines clause? And if so, what would it be?
I think it doesn't matter particularly for this case with regard to this excessive fines clause. Like it applies equally for criminal forfeitures or civil forfeitures. As Sam was just explaining, the excessive fines clause means that the punishment has to bear some reasonable relationship to the crime that happened. I think where the differences between civil forfeiture and criminal forfeiture might kind of bear on the excessive fines clause is in civil forfeiture, you see situations in which the person who's losing their property may never have been charged with a crime at all, and in fact, actually may never have been accused of committing any kind of offense, right? Somebody else might have actually committed an offense with their property. And that raises a sort of separate excessive fines issue. And this is one that maybe we'll talk about because we're arguing it in our Detroit forfeiture case. But what does it mean when someone is punished for the crime of someone else? And as Sam said, typically the excessive fines clause is a very individualized analysis of how bad is this crime? How high is this penalty? And we kind of look at these things together. But in the context of civil forfeiture, you have situations in which someone is being punished for literally a crime that they did not commit, that somebody else committed. And we would submit that, in any kind of penalty in that regard would violate the excessive fines clause,
Right.
because any penalty at all for the crime of nothing
Right.
is excessive per se.
Can you explain sort of the difference between criminal forfeiture and civil forfeiture? Because it sounds from what you just said as though, civil forfeiture involves a guy who is wholly innocent and criminal forfeiture involves a guy who maybe did something, but the way he's being punished is kind of vastly disproportionate. But that's not as clean as that, right? Because the Tim's case that Sam was bringing up, there was a, actual crime, at least charged there. I don't remember if he was actually convicted, but I think he was. But it was still civil forfeiture at play there. And so help us untangle that.
Yes, it's not. Yeah, you're exactly right. It's not as if in civil forfeiture that's every case is right. This innocent owner and somebody else did something wrong with the property. The main difference is that criminal forfeiture is part of the criminal sentencing process. So after somebody has been tried and convicted of a crime or has pled guilty to a crime, they can then be deprived of the sort of instrumentality of the crime or the proceeds of that crime through the sentencing process and through the criminal forfeiture process. It's all kind of built in together in this criminal prosecution. Civil forfeiture can happen where somebody is actually charged with a crime, whether that's just, someone's like arrested for a crime and then ultimately the charges go nowhere, or as you said, it even goes to full, conviction and sentencing. But it happens kind of in parallel to that, and it happens in a separate proceeding, as the name indicates. It's a civil action in nature. So that's why these cases have like strange names, like the people of the state of Michigan versus a 2006 Saturn Ion, right? Because the action is actually proceeding against the property itself. It's not part of the criminal action that's against the criminal defendant.
So it's striking how much IJ's forfeiture cases kind of overlap with other areas that IJ litigates in, whether it's Fourth Amendment, free speech, kind of all of these other areas. Can you kind of highlight some of those different places where there's this overlap?
Yeah, so I think part of the issue here is that civil forfeiture violates a lot of constitutional rights in a lot of different kinds of ways, and so it raises issues kind of across the board of what IJ does. And Sam was talking about how the excessive fines clause bears on, our fines and fees work, and this kind of proliferation of using fines and fees or forfeitures for revenue. And so there's a lot of overlap there between forfeiture and kind of our fines and fees work, because in the forfeiture context, we see a lot of this, as we say in our strategic research report, policing for profit, of looking for ways to pad law enforcement budgets through forfeitures. And we also have overlap with our Fourth Amendment project. We have issues of taking property for the sole purpose of forfeiture, where, as in Detroit, there were, for our clients in our Detroit forfeiture case, they were never charged. No one was ever charged, well, we'll get to maybe one of them who was charged when overlap with First Amendment issues. But two of our clients were never charged or even accused of having committed any kind of crime. And so at that point, the only justification for the government of holding their property is to make money, right? They're not trying to stop crime in any meaningful sense, because there was no crime that they're charging. They're just holding this property for the pecuniary gain of the government. And there's no Fourth Amendment, warrant exception to the government wants to make money. So there's some, I think, serious Fourth Amendment issues there with the warrantless seizures and ongoing seizures of people's vehicles, which they really need, just to try to ensure that the government can have those vehicles to take through civil forfeiture. So there's Fourth Amendment overlap. And then some immunity issues that come up in forfeiture with our Project on Immunity and Accountability, of trying to hold government officials accountable for various forfeiture practices. And what I kind of alluded to as First Amendment overlap here in our Detroit forfeiture case is I had thought that our Detroit forfeiture case had been going on for a long time, though now after Sam's talking about Tim's and this last case, I'm like, okay, 5 years is rookie numbers.
You've been involved with the whole time.
Yeah, right. But the Detroit forfeiture case has been going on for quite a while and has spawned sort of other cases. And one of those other cases is a First Amendment retaliation case. So just a few days after we filed our federal class action lawsuit challenging Wayne County's vehicle forfeiture scheme, one of our clients, Robert Reeves, found himself criminally charged with having received and concealed stolen property. And it was very evident that this was because he had just filed a federal civil rights lawsuit challenging Wayne County's forfeiture program. We worked with him and had the criminal charges dismissed. He then found himself charged a second time. And again, I think, you do just look at the timing of this, the fact that he was the only one who was charged twice out of this alleged criminal conspiracy of many people, where, the people who were actually doing the theft of this allegedly stolen property were never charged. Only Robert found himself charged 2 different times. And just some statements by the lawyers and how they were attempting to use this criminal prosecution in our federal case to try to get the court to abstain from hearing Robert's claims. There are a lot of different pieces that just made it really evident that the reason Robert was charged is because he sued the government and spoke out about this injustice, which is totally unacceptable under the First Amendment, right? You have a right to petition the government for the redress of grievances, including through litigation, and you have the right to speak out about injustice and the right to speak about things the government is doing that are wrong. So we represented Robert in a First Amendment retaliation lawsuit against Wayne County and against their corporate counsel and the prosecutor who brought the case, and are still litigating that and trying to represent him in this First Amendment fight that's sort of related to our forfeiture work as well.
So going back to the class action in Detroit, we had a win there recently, right?
We did have a win a couple months ago where Wayne County had filed yet another motion to dismiss, trying to get Robert specifically. He's one of the 3 plaintiffs and named plaintiffs in the case, dismissed from the case. And we defeated that motion to dismiss, which really kind of puts the wind in our sails going into, we have a big hearing coming up in less than a month on both class certification and cross motions for summary judgment, which basically means both sides are asking for a definitive answer in this case. And and that will be before the court on September 11th. So we're, excited to see what will happen there. I'm sure, as I mentioned, this case has been going on for quite a while. So there will be many more updates, I'm sure, on the Detroit forfeiture case and how that progresses. But we've got a light at the end of the tunnel, at least in the trial court, that we're hoping to get some more news in the near future in Detroit forfeiture.
If we end up prevailing in Ken's case, what's...
Well, first, where's Ken's case at? Like, what...
Maybe better
we should
question.
Talk about that. Yeah.
Okay, we'll circle back to your question.
And then we'll get there.
Right. So the Alaska Supreme Court rules against Ken this past April. The case is basically now over in the state courts. We will be petitioning for review from the U.S. Supreme Court. Perhaps by the time this has come out, we will have petition for review late August, early September. And then there's kind of a briefing schedule where the state can respond and say, no, there's nothing to see here. We can file a reply. The case ultimately, I think, probably by the end of 2025, early 2026, will be up for what's called a conference at the U.S. Supreme Court, and they're going to decide, is this one of the very few cases that we are going to set for oral argument and take up on the merits? And so that's kind of what we're looking for right now. Now, Keith, I want to hear this question.
Well, so if this process plays out as we want it to play out, and there's no guarantee that it will, it's always a long shot when we ask for cert. These are hard cases. But if it plays out like we want it to play out, the Supreme Court takes the case and we win, what's the next step for us in the excessive fine space? Because
we'll rely on that authority in our Detroit forfeiture case.
Oh, there we go. So the first thing we'll do is we'll use it to lead ourselves to victory in Detroit forfeiture. But is there another step for us, kind of in terms of building case law that we want to see to kind of change the world? The mission that IJ has.
Yeah, no, I don't think we're going to give up on excessive fines after hypothetically winning this case at the U.S. Supreme Court. No, I mean, there's just a lot of open questions when it comes to the excessive fines clause. And in part, that's because what we were talking about earlier, that it really wasn't until the late 80s, early 90s that the Supreme Court started issuing rulings about the excessive fines clause. The only excessive fines ruling they've issued this century has been the Timms case, which was our case. So there's just a lot of kind of divisions in authority in the lower courts about, like, for example, like, should the courts consider someone's ability to pay a fine in determining whether it's excessive? What is a fine, right? Like, we asked the Supreme Court to take a case a couple of years ago where the federal government had, I was going to say fined, but civilly penalized an octogenarian lady to the tune of like $3 million. And the First Circuit said, well, that's not a fine, it's a civil penalty, so the excessive fines clause doesn't apply at all. So there's lots of issues out here. But I think Ken's case is exciting because I think it really goes to kind of a fundamental conceptual issue. It's not about like, which 10-factor test is better than which 17-factor test. It really is about, everyone agrees that we should be looking at the gravity of people's offenses when we're kind of balancing whether a fine is disproportionate. And just kind of how do we go about even thinking about the gravity of that offense? Is it like the gravity of Ken Joby's offense, or is it the gravity of the hypothetical worst case offender of this statute? Obviously, we say it should be Ken's, and I think having the Supreme Court reinforce that and clarify that will go a long way towards helping the lower courts start to kind of get their cards in order on how they think about these cases.
Thanks so much, guys, for coming in and talking with us about this today. And thanks so much to all of you for listening. If you'd like to see more of our videos, you can like and subscribe to our channel. And if you'd like to support this work, you can do that with just $5 a month at ij.org/monthly. Thanks so much.
Thanks again for watching. Make sure to like, subscribe, and tune in for more videos.